For admission, item number 1.
May it please your Lordship. Lordship, I appear for the petitioner in item number 1.
Yes, so have you filed your amended petition?
Lordship, we filed our amended writ petition.
You have
on the
filed it?
last on the last occasion.
Yes, okay.
Lordship, the respondents had sought time to file their affidavit in
Yes,
opposition
who's
to
the
our amended.
respondent?
I appear for the respondents, my lord.
Yes.
On
you
the
have
respondents,
filed your
IOCL.
reply? Yes.
Yes, I have sought I seek further time to file my reply, my lord, the amended petition.
You're going to file a reply or you're going to file a counter affidavit? Which one?
My lord, there's a counter affidavit, my
I
lord. That
think
will be
it
an
should
additional
a
counter affidavit.
Counter affidavit, isn't it?
Yes.
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 Miss S.
S.
Kataki. Is it?
Kataki, S.
Yes.
Kataki.
Learned counsel for the petitioner along with Mr. N.K. Barwa.
Yes, ma'am.
Learned counsel for the respondent both appear through VC. Mr. N.K. Barwa, learned counsel for the respondents, okay, has prayed for further time to file their counter affidavit to the additional affidavit filed by the learned counsel for the petitioner on 29/10/2024. In view of the above, list the matter after. How long will you take?
My lord, may kindly fix a date in the month of January, my lord, for the sake of convenience, so that we can appear in
In view
person,
of
my
the
lord.
above, as prayed for, list on. Give me a date for January.
31st January, if it's convenient with your Lordship.
Fine. 31st January 2020.
Lordship, there's an interim order.
Meanwhile, the interim order passed earlier shall continue till the next date of listing. Yes.
Highly obliged.
Highly obliged.
Item 2.
May I praise your Lordship. Lordship, that is a very simple application for taking a Jimma of a vehicle. And if your Lordship, I will want to take your Lordship kind attention in the judgment and order passed by this Honorable Trial Court.
This is for taking out what?
Jimma, your Lordship. It is Jimma,
Yes, for what?
Jimma of a
What?
vehicle.
Is it a vehicle
Yes,
or
yes,
what?
vehicle.
Your Lordship,
And Lordship, in the lower court, learned standing counsel for DRI has not objected, and that learned trial court has said that investigation is not completed. But your Lordship, if your Lordship says that the seize of vehicle was 23/4 and 6 months already gone, your Lordship.
Investigation not complete till date? Has
Not
charge
yet. Nothing has filed by the DRI. Sometimes your Lordship DRI takes 1 month, 1 year, 2 year also filing charge sheet.
Your
Charge sheet is
Lordship,
not related to that matter.
I'm representing my senior, and right now my senior is in Bangkok to present his paper. So he will be out of station till the first week of this December. And although we have submitted the leave of application, and it seems that it was still highlighted in the cost list. And so if the
What
matter,
was highlighted?
we have submitted the leave
They
of
have already
application
submitted their-
on last Friday.
Their objection?
Yes, report.
Okay, then you'll have to hear the matter. Let him be present, isn't it? So you have filed your written objection. So since he is not able to appear today, we will fix another date. Then maybe we can dispose it of on that day, isn't it?
Lordship.
Well, where has he gone, Mr. Johnny L. Tausong?
He has gone to Bangkok to present his doctorate paper.
Okay, very good.
So he will be back on the first week of this December.
Okay. Mr. A.H. Barbuya, learned counsel for the petitioner, is present, while mention is made on behalf of Mr. Johnny L. Tochong, learned counsel for the opposite party, for adjournment of the matter, since the learned counsel is said to be out of station. It is also submitted that their written objection. Where is it? It's not there in the file.
Written objection.
Have you filed your written objection?
No, ma'am.
Yes, it's already filed. It's already filed. Report has already been filed.
You have received a copy?
Not yet.
Ma'am, I will check.
It is not required because
I
your
am
Lordship.
Okay, okay, out of station. in view of the above, as prayed for, list on, when do you want
3
it?
weeks.
Give us a date. December, first week.
Yes.
First
So
week.
can we fix it on the 6th
Yes, Your
December?
Lord- Your Lordship.
Okay, 6/12/2020.
Oblige.
Oblige.
Item 3.
I seek your lordship's indulgence, my lord. Since this writ petition is quite bulky, I have not yet received the Parawise comments from the concerned departments. So if I may be granted another
How many
3 weeks
adjournments
time.
have you prayed for?
This is the first time.
So here it says that an attempt will be made.
Yes, my lord. In the last court order, it was said that.
You are for the state respondents and then any other respondent?
No, my lord.
Even if the writ petition is bulky, the issue may be not so voluminous, isn't it? It's bulky because a lot of documents have been submitted. The main body of the writ petition is not that bulky, isn't it? Here, a lot of other documents have been submitted, English translation. Anyway, we'll give you one more chance.
Yes, my lord.
Are you pursuing the matter?
Yes, my lord. I have contacted the departments.
In the meantime, my lord, the interim stay may kindly be continued.
Okay. Has it been granted? Not yet.
On the 22/10/2024 order, my lord.
December 4.
Okay, should we stay till the next returnable date? Huh?
My lord.
Heard Ms. Valentina Laldinpui, learned counsel for the petitioner, along with Ms. Caroline K. Laldungonpui, learned government advocate for the state respondents. The learned government advocate has prayed for further time to file their counter affidavit. Ms. Valentina Laldinpui prayed that the interim order passed earlier may be continued. In view of the above, list the matter
After 3 weeks, my lord.
after 3 weeks. Meanwhile, the interim order passed earlier shall continue till the next date of listing. Yes.
Oblige.
Supplementary cause list. Item 4.
Item 4 is taken by Miss Mary, and the file is with her at her home, and she has been the baby has been hospitalized.
Yes, yes, Miss Mary. Ah, yes. Madam, how is your child now? Better?
Better, my lord. We hope to get discharged today.
Okay, very good. So can we have the bail hearing today or should we
Yes, my
adjourn
lord.
it?
Yes.
Hmm?
Yes, my lord.
Okay. Yes.
May it please your lordship. The petitioner was arrested on 5/2/2023 in connection with the seizure of 503 grams of heroin from Hotel Grand Plaza, room number 404, which was occupied by the present petitioner and her friend. So I will not mention her friend because he's a juvenile at that time, my lord, and he was sent to JJB.
Okay.
And
Juvenile,
my lord, I am raising only one ground, my lord.
Okay. Now, when the matter was placed before the special court, was it, let's see, the grounds for rejecting?
Yes, my lord.
Why was it rejecting?
Page number, my lord. From page number 57 to 60, my lord.
Previously, you had prayed for bail
Yes, my lord.
on the grounds that you were suffering from something. Okay?
Yes, my lord.
Liver
But
problem.
yes. But no, my lord, I am
Now
not.
she's okay?
Okay.
So now you've approached this court not on medical grounds, on some other ground.
Yes,
is it?
my lord. Because she has been taken care of in the
Yes,
in the
you
central jail,
get
my
good
lord.
medical care in central jail.
Yes,
Okay,
my
what
lord.
is the seized amount?
503 grams, my lord.
Oh. So what's the reason?
My lord, before I go to my grounds, so I will read first the FIR. So this will make the picture clear, my lord. Who are the involved persons, and that is at page 16, my lord.
Yes, page.
16, my lord. I have the honor to report that on 5/2/2023 at 12:50 p.m. at Bongkon Lunglei Road, section at Hotel Grand Plaza, inside room number 404 and in the presence of the two independent civilian witnesses, I seized the below noted articles. In connection with the seized articles, I arrested the below noted persons for possession of the seized articles on the same date, time, and place. Arrested persons: 1. Zetram Puyi, the petitioner, daughter of so and so, resident of so and so. 2. He is a juvenile, my lord. 3. Lalom Zuala, son of so and so, resident of so and so. Seized articles: 503 grams of suspected heroin, kept in 39 soap cases, further kept in a black color backpack. The essay, which I mark as S1 to S22, were wrapped into duct tape. Essay, which I mark as S22, was recovered from inside the bottom of cardboard of room number 404. The concealment bag was recovered besides the bed at the floor. The cited room number 404 was occupied by the accused, Zetram Raupuyi, and he was a juvenile. And the accused Lalom Zuala claimed ownership of the concealment bag in the presence of witnesses. Here, my lord, my first ground is I have no conscious possession. I had no knowledge about the essay which was seized in the instant case, and I had no control over the essay, my lord. So the seizing officer also clearly stated that the essay was claimed by the co-accused Mr. Lalom Zuala.
So charge sheet is submitted?
Yes, my
not
lord.
discharge. Then?
And then trial is almost finished, my lord.
Then you wait for the trial to be finished.
My lord,
How many witnesses examined?
5 witnesses out of 6, my lord.
And when's the next court date?
I don't know, my lord, because I am not the counsel in the trial court, my lord.
Okay. Yes.
And my lord, to support the FIR, the co-accused Mr. Lalom Zuala had clearly stated that he was the transporter of the essay from Chiao to Aizawl, and then he will earn 3 soap cases out of it for transporting.
Where you talking?
At page number 30, my lord. So this is the statement before the case IO, my lord.
So, but let's see what he says once he's examined under 313, isn't it?
Yes, my lord.
So you have prayed for bail
Yes.
based on the statement made by the co-accused, is it?
Yes, my lord.
Page
And also, my lord, the case IO in his examination in chief at page number 44,
What did he say?
at point number 4, clearly stated that the accused Mr. Lalom Zuala claimed ownership of the essay, my lord.
Then he should have discharged them if they're that innocent. They must be having some case, isn't it?
Yes, my lord.
But he did not find it fit to discharge the present applicant, petitioner. Okay. Yes. Is that all?
My lord, may I read the page number 30, that the statement of Mr. Lalom Zuala, the co-accused. He is a habitual offender. He had another case in Champhai. Also, my lord.
So you talk about yourself.
Yes, my lord. My lord, yes. the essay was recovered from hotel room number 404.
Okay,
That
and
was
you were inside the room?
yes.
Is it?
That
Oh.
yes. That was exactly. We don't deny that we
What were
occupied.
you doing in the room?
Sorry, my lord.
What were you doing in the room? What were you
You know, my
doing
lord.
in the room?
On 3rd February, I went to Champhai because before that, from Lunglei, I went to Aizawl to sell my scooty and torque. And on the next day, I sold it for a sum of rupees 80,000. And then Mr. Lalongzola, my co-accused, came from Lunglei to Aizawl. And then we met at Aizawl. And then he went on the next day. He will go to Champhai to attend his court at Champhai District Court. And so we have never visited Champhai. With my friend Mr. So and so, I went to Champhai along with him. So on 4th February 2023, so we were still at Champhai. So the co-accused Mr. Lalongzola went to jail. And then he brought some the seized articles. And then after that, with his scooty, we went back to Aizawl by a triple riding. And the co-accused, Mr. Lalongzola, got off at
All that she has to state.
yes,
313.
and then by Sumo. And then we wrote his scooty. And then we stayed at hotel room number 404, Hotel Grand Plaza at Lunglei. And after we reached Aizawl, staying at hotel room number 404, Mr. Lalongzola also stayed at the next room. And then he kept his bag, which was used for concealing the essay, and he kept beside my bed without my knowledge, my lord. And on the next morning, that is on Sunday, 5/2, and then he sold one soap case. So from that moment, it came to my knowledge that he kept some amount of heroin in his bag, my lord.
So
And then
did she
shortly,
report the matter? Did she report the matter? No.
no, my lord. And shortly after, my lord, there is no time to report. Shortly, the excise personnel came to that hotel room, my lord.
Yes. Any judgment? to
Yes, my
rely
lord.
on?
A coordinate bench of
This one, okay. Relevant is where? Para? Oh, okay.
My lord,
Para?
this one, that is the bail, that is the judgment, my lord. Para 11, that is Onyx my pop. Para 11, my lord. May I read, my lord? In the case of Murlidhar Soni, the son was driving a scooter and his father was a pillion rider and carrying few kgs of ganja in a cloth bag. In this situation also, the Honorable Supreme Court has held that the son who was driving the scooter cannot be said to have conscious possession of ganja, and his acquittal was approved. In the case of Balkar Singh, the accused persons were found sitting on a cluster or bags kept in a field containing large quantity of poppy hulls. Despite that, the apex court has approved the acquittal of the accused persons, holding that there was no investigation how the strangers had transported 100 bags of poppy hulls to the place of recovery, nor the prosecution adduced any evidence about their ownership. In the case of After Singh, the accused were traveling in a truck and the bag over which they were found sitting was containing narcotic drug, and in this case also, it has been held that the accused cannot be said to be in conscious possession of the narcotic drug. Their lordships have held that possession and ownership need not always go together, but the minimum requisite element which has to be satisfied is custody or control over the goods. While acquitting the accused persons, their lordships have further observed that the persons who were merely sitting on the bags in the absence of proof and nothing more cannot be presumed to be in possession of the goods. In the case of Hari Singh Supra, the Honorable Supreme Court was examining a case wherein 3 men and 2 women were found sitting on the bags containing narcotic drugs. Their lordships have held that the word conscious means awareness about a particular fact, and it is a state of mind which is deliberate or intended. Their lordships have further observed that To hold a person in conscious position, it is not necessary to prove that he was found in physical position of offending articles, but it has to be proved that such person had constructive knowledge of such an article and had the power and control over it. Having said so, the acquittal of the accused persons for possessing 30 kgs of poppy hash was upheld. Para 12, my lord. In the case before me, the factual scenario is little better. Not a single appellant was found sitting in the truck that was carrying ganja. In the case of State of Maharashtra versus Sukhdev, AIR 1992 SC 2100, and in many other judicial pronouncements, it has been held that more stringent is the provision of conviction, more rigorous investigation and trial is necessary. Besides this, in the case of Ismail Khan, Ayub Khan, Pathan Supra, it has been held that mere presence of a person at the place of recovery is not sine qua non of his involvement in the offense. It is also settled law that suspicion, however grave, cannot take the place of proof, even if moment of appellants at the place of recovery in suspicious manner is considered to be an adverse circumstance. That is not enough to affirm their conviction in absence of corroborative, additional, incriminating circumstances. My lord, my humble submission is that the co-accused, Mr. Lalomzola, has not made any retraction statement till date, my lord. And besides this, my lord, the present petitioner, she was only 20 years old at the time of her arrest. She had completed her class 12 education. Because of being arrested and detention in custody, my lord, she could not pursue her further education, my lord. So I humbly pray your lordship to kindly grant the petitioner in the interest of justice, my lord.
Okay, yes.
My lord, what my learned friend have relied upon is the 161 statement of the co-accused. Now, this is a case wherein trial has already commenced and evidence is already taken. I'll just take your lordship kind attention to the relevant evidence on the page number 49, my lord. Page 49. This is the examination of the Caesar witness.
Yes.
Para number 8.
Yes.
On interrogation, accused Z. Ramropi, this is the present petitioner, confessed that they transported the seized article from Tiao. Accused Lalomzola stated that he was the owner where the bag was the seized where the bag where the seized article was concealed. Just that he was the owner of the bag where the seized article was concealed. Now, my learned friend have relied on the 161 statement of the co-accused. If they want to take that into a defense, they can adduce the evidence before the learned trial court, and because the evidence is almost complete, prosecution evidence is almost complete at this stage.
You don't know when the next date is fixed or whether the last prosecution witness, has he been examined? Any idea?
My lord,
That
the remaining prosecution witness is the JMFC.
Okay.
She is posting in the scholarship, my lord.
Okay, Colisip is not far off. I
Yes,
think
my
they
lord.
should come soon.
My lord, regarding my the learned PP submit that regarding possession. So in his 161 statement, that is the seizing officer, he was silent about the ownership, my lord. So that is an improvement made only before the court, my lord.
My lord, anyway, on this paragraph alone, conviction can be.
My lord, she will give her evidence also, my lord. So she had no benefit at all, my lord. She
And-
at a young age, my lord, she was a student.
My lord, my learned friend have relied on the judgment. I don't know the judgment because the citation is not given to me, and then it's not.
What is the citation?
But anyway, from what I heard, if I'm not mistaken, this is regarding the trial and the conviction, but it's not with regard to bail. The ratio taken is not regard to bail, my lord. And but presuming but not admitting that it is taken into bail, but it talks about constructive conscious possession. Now, this paragraph number 8, page 49, have already shown that there is a constructive knowledge of the conscious possession of the petition.
Okay. But Mr.
Yes, One Love Sheta.
S. Vallabh Sheta, learned counsel for the applicant slash petitioner, along with Mrs. Mary L. Kiangte, learned additional PP for the state respondents. Matter is reserved for order. Yes.
Highly obliged.
Anything else? It will be out by tomorrow or the after during this